All rise.
The Kosovo Specialist Chambers is now in session.
Madam Court Officer, you may call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hysni Gucati and Gucati&Haradinaj.
Good morning, everyone. Welcome. I would ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office.
Good morning to the panel and everybody here and joining us remotely. For the SPO today, we have Ms. Valeria Bolici, Prosecutor, Lena Peterson, Case and Evidence Manager, Matt Halling, Associate Prosecutor, and I am James Patch, Associate Prosecutor.
Your Honour, I appear on behalf of Mr. Gucati. I'm assisted by co-counsel Mr. Hugh Bowden and Miss Eleanor Stevenson. I'm also assisted today by Miss Faye Wigmore, Mr. Joseph Bowden and Mr. Remy Halilai. Thank you.
Good morning. I appear for Mr. Gucati&Haradinaj, who's appearing remotely. In the court with me today is Mr. Omar Solomon, Miss Clarissa Rodio, Mr. Admir Berisha, and joining us remotely is Miss Miriam Boxberg.
Good morning, panel. Good morning, everyone else. My name is Ralph Roach from Judicial Services Division in the Registry. Thank you.
I also note that Mr. Gucati is present in the courtroom and Mr. Haradinaj is following the hearing remotely, as Mr. Cadman indicated. Today we hold the Defense Preparation Conference, which precedes the opening of the defense case. And before we start, for the benefit of the public, I recall that the prosecution opened its case on 7 October and presented evidence between 18 October and 5 November. The prosecution formally closed its case on 10 November of this year. On 26 November, the panel decided not to dismiss any of the prosecution charges at this stage. That decision opened the way for the defense case to start if the accused so elected. On 29 November, pursuant to Rule 119, both accused filed their lists of proposed witnesses. The Gucati defense also filed a list of proposed exhibits. On 30 November, the panel issued a scheduling order for the defense preparation conference to be held today and, if necessary, tomorrow. The purpose of this conference is to prepare for the defense case. We will go through the agenda set out in our scheduling order and also address some other issues, including those flagged by the parties as late as yesterday. The first item on the agenda is the opening statements. Can the defense confirm that they will be making opening statements? And if so, would they both be made on Monday, 6 December, or would the Haradinaj opening statement be made after the Gucati defense finishes its case? Also, I'd like you to address how much time you expect to take up with these statements. Mr. Reese.
We will make an opening statement, Your Honour. I anticipate it'll be something in the region of up to 45 minutes. We can make it on the 6th of December. We can make it earlier if the trial panel so wishes. I think that answers the request as far as Mr. Guzzati's case is concerned.
Thank you, Mr. Rees. Mr. Cadman?
Your Honours, I did file a very short note this morning. It may not have made its way to you yet because it was only filed this morning in relation to some of these points. It is the intention of the Haradinaj defence it is the intention of the Haradinaj defence to make an opening statement, but it is the intention to make it at the conclusion of the Guzzati defence case.
Thank you very much. The next topic is
Microphone, please.
The next topic is the accused's attendance in the courtroom during the defense presentation of evidence. In light of the COVID-19 situation, we need to take into consideration scenarios where the accused cannot be present in the courtroom. Just to clarify, it is the clear preference of the panel that the accused attend in person, but we know that this is not always feasible because of COVID-related restrictions. I will first give the floor to the registry. Mr. Roach, what the panel wants to know is whether the accused can follow the proceedings from the detention unit in the event they cannot be present in the courtroom, including in quarantine situations.
Thank you, Your Honour. In the event that, based on medical advice, an accused is not able to attend court and is required to quarantine, we have facilities in place for the accused to follow and participate in the proceedings as necessary from the detention facilities, including direct access to evidence and other materials. So the answer is yes, it can be facilitated.
Even if he's in quarantine?
Yes, because yes, that is the case.
Okay. Also, could you please tell the panel whether any restrictions apply to the possibility for counsel to have access to their client at this stage, and if so, what are those restrictions?
Currently, in-person visits are not yet resumed at the detention facilities. They will be as of Monday, the 6th of December. The accused have been able to maintain telephone contact with their counsel at all times as of the implementation of the self-isolation on medical advice, and we are also able to facilitate Zoom meetings upon request, and we have offered those to counsel and their accused.
Now, I presume that thank you, Mr. Roach.
Okay, thank you.
I presume that the preference of the defense, of course, is to have the accused in the courtroom, but I will give the floor to you to speak in this regard. Mr. Rees, I don't know if you have anything to add.
Mr. Guzzati is here. He has been here throughout the trial, and we intend that he will continue to do so, save for any unforeseen events that might preclude that.
Thank you. Mr. Cadman, your turn. And can you also tell the panel whether the problem you flagged yesterday with the secure electronic disclosure system has been resolved by now?
Dealing with it in reverse order, yes, it has been resolved. We are able to transfer documents securely now. What I would say is for Mr. Haradinaj, the situation is slightly different because he is still displaying symptoms of COVID. As you've heard from Mr. Roche, we don't have any direct access other than through secure electronic communications. It does cause difficulties as far as being able to take instructions during the trial. For that reason, I think it would be advisable, as we have suggested, for the Guzzati defence to go first and then the Haradinaj defence to follow. That will enable me to be able to have greater contact with Mr. Haradinaj when we present our defence case. At the moment, we've been informed that he has to remain in quarantine until at least tomorrow. We don't know. They haven't taken a test because he's still displaying symptoms. Once we know the position, then we will continue. What Mr. Haradinaj has instructed is that he does not want his inability to be physically in the court to delay matters any further, bearing in mind he's been in custody for 14, 15 months now. He really wants this matter to press on. So those are my instructions, but obviously it will limit the ability to properly present his case if I don't have contact with him.
Thank you very much. We do appreciate everyone's cooperation and patience, which you've been showing, and it is, of course, our intention to try to keep going forward in this case to reach a conclusion as soon as is possible. And Mr. Haradinaj, we thank you for your presence today, and we hope you are feeling better soon. The next topic is the SBO challenges.
Yes, I'm good.
Thank you.
The next topic is the SBO challenges against defense witnesses. This issue also goes into the panel's authority to determine the number of defense witnesses during this conference as provided in Rule 119, paragraph 3A. Before we go into this topic, a brief procedural background is warranted. On 12 July 2021, the defense filed their respective pretrial briefs together with provisional lists of proposed witnesses. The two lists were identical except for an additional proposed witness on the Haradinaj list. On 21 July, the panel ordered the defense to file a summary of facts or circumstances in relation to which each witness on the defense provisional witness list would testify. On 27 August, pursuant to the 21 July order, the defense made additional submissions regarding the purported relevance of the proposed witnesses. On 15 September, the SBO filed a request to remove 5 witnesses from the defense lists and limit the testimony of 5 other witnesses to matters relevant to the charges. On 27 September, the defense responded to the SBO request. On 15 of October, the Haradinaj defense filed the expert report of the first proposed expert witness. On 22 October, the SBO filed its challenge to this report. On 9 November, the Haradinaj defense filed the expert report of a second proposed expert witness. On 16 November, the SBO filed its challenge to this report as well. On 29 November, the defense submitted their Rule 119 filings as follows. The Gucati defense submitted a list of 8 proposed witnesses, of whom 2 are new, in the sense that they are not mentioned in the provisional witness list. One of these new witnesses is Mr. Gucati. The Gucati defense also submitted a list of proposed exhibits. The Haradinaj defense submitted a list of 7 proposed witnesses, of whom 2 are new, and one of those new witnesses is Mr. Haradinaj. Having reviewed the new list of witnesses, the panel notes that the defense no longer intend to call 8 witnesses who were listed on both initial lists of witnesses. 5 of these witnesses were challenged by the SBO, so those challenges are moot. On the 1st of December, the SBO submitted a new challenge requesting the panel to remove defense witness 1248 from the Gucati witness list and not authorize improper opinion evidence in relation to 5 other witnesses, 4 on the Gucati list and 1 on the Haradinaj list. The panel further notes that there is an outstanding issue regarding the classification of the Gucati list of exhibits, that is F460 Annex 2. The panel invites the SBO to address this matter if need be in private session. Mr. Prosecutor, I invite you to make any additional submissions you might have on the question of the witnesses that the defense may call. Since you made a filing yesterday, I presume you don't have much to add, but the floor is yours if you do have something to add at this time.
Thank you, Your Honor. And with your indulgence, I'll just briefly go back to the issue of opening statements in light of what the defense or Mr. Haradinaj said. I know that it doesn't seem to be a situation envisioned under Rule 101-262 that there's a staggered defense opening 1262 refers to either following the opening statement of the Special Prosecutor or after the conclusion of presentation of evidence by the Special Prosecutor and before the presentation of evidence by the defense. The presentation of evidence by defense will commence next week, and the defense is for the witnesses are being called in relation to both of them. I understand the Haradinaj defense will be leading direct examinations, if necessary, of the witnesses called by Mr. Gucati. So in that regard, it's not clear to us that the proposal put forward by the Haradinaj defense is actually acceptable or logical. But of course, it's up to the chair.
Are you raising an objection?
Your Honor, I'm noting that it doesn't seem to be envisioned as a possibility under the rules. Of course, Your Honors could prefer that or deem it acceptable, but in terms of compatibility with the rules, it doesn't seem to be compatible. Our preference, yes, the SPO's position, is to have both the opening of the Gucati and Haradinaj defense at the same time, which would be before the start of any defense case. But of course, as I said, if the trial panel doesn't see an issue with it, then it's of course within your discretion. I'll turn next to the current agenda item. The SPO maintains the requests set out in relation to defense witnesses to the extent they are not moot by virtue, as Your Honor has already mentioned, of the defense having decided not to call certain witnesses. I will make brief additional submissions without repeating what we set out in filings F312, F388, F438, and F466, which is yesterday's filing. On the 30th of November and the 1st of December, the defense disclosed statements of witnesses addressed in our filing F312. These statements make the irrelevance of the proposed testimony of certain witnesses and their inability to assist the trial panel in the determination of any relevant matter even more clear than they were at the stage when the prosecution opposed such testimony. Before I go into the next few points, I seek some clarity from either the defense or the panel. I want to address a couple of issues specifically raised in statements which have now been provided to the prosecution. I note that the witness statements annexed to the Haradinaj submissions were filed confidentially. I could not myself find a classification for the statements disclosed by the Gucati team. And I also note that, of course, no protective measures are being sought. So the guidance I would like is as to whether I can refer to specific parts of defense witness statements in open session, or whether it would require me to go into private session.
We have throughout encouraged and urged openness and transparency. We have no issue with these matters being dealt with in public.
Likewise, Your Honor.
Microphone, please.
Your question, Mr. Patch?
Certainly, Your Honor, and I appreciate the defense's clarification on the matter. So as I was saying, a number of the disclosed witness statements make the irrelevance of the proposed defense witness testimony, and their inability to assist the panel even more clear than they were before. And I'll be brief, I'll mention a few examples. I'll first address the statement of DW1251. The statement doesn't seem to have an year-end, but it's contained in pages 11 to 36 of Annex 2 of filing F461. The statement expressly says it contains some of the evidence that this witness would provide to the Kosovo Parliament. The KSC is not the Kosovo Parliament, and this trial panel is not dealing with matters in any way relating to what the Parliament may be or may in the future deal with. The KSC is a judicial institution, and this trial panel is seized with a specific case where two persons have been accused of committing several crimes. This case and this courtroom is not an alternative forum for someone to air their personal grievances. Indeed, this witness's statement amounts to a list of complaints, criticisms, and allegations by the witness about EULEX, a separate institution to the one we are in today. The statement bears no relevance to this case whatsoever. In its 26 pages and 125 paragraphs, the statement only makes mention of the KSC, the SPO, or the accused when the witness provides unfounded allegations and the relevant opinion about the KSC, the SPO, or the accused. And that's in about 10 of the 125 paragraphs. opinion by non-experts, which is not grounded in fact, cannot assist the trial panel in this case. Similar considerations apply to the 29-page, 117-paragraph statement of DW 1250. I won't delve into that in further detail because, as I said, the arguments are the same or similar at least. The last example I will give, which really bears out the irrelevance and the inability to assist the trial panel by certain defense witnesses, is in relation to DW 1246. In his statement, which is DHG 0181 to DHG 0183, the witness seems to assert that he wasn't even in the country when the relevant events to this case happened, and he specifically acknowledges he has no knowledge or competence to address any investigations which may have been undertaken by the SPO in relation to relevant events. He also offers what he terms his, quote, personal opinion, end quote, about the manner in which the SPO conducted the search and seizure and arrests, which opinion is both improper from a fact witness and entirely irrelevant to the charges. I also would like to note, and Your Honor, if you deem this more appropriate to address at a later stage, I can do so. I think it falls within the current agenda item. That rather than providing, in relation to any witness, a summary of facts on which the witnesses for the defense are expected to testify, which is required by Rule 1192A4, the defense has merely referred to witness statements provided. So at this stage, the SPO seeks confirmation from the defense that this means that no matters other than those specifically addressed in each of the statements will be raised during direct examination. That's one request. And in this regard, we note that despite seeking admission of all or all but one, at the moment it's unclear, of admission of all but one statement by defense witnesses pursuant to Rule 154, whereas for certain witnesses, the defense estimates a few minutes in direct examination, we have an estimate of 2 or 3 hours for the direct examination of the accused, and then of 45 minutes to an hour in relation to certain other witnesses. So again, the clarity we seek is in this lengthier direct examination, is the expectation that the witnesses are going to be sticking only to matters strictly addressed in a statement, or are they going beyond? And to be clear, our position, in fairness, is the one we set out during our own case, which is you can go beyond matters addressed in a statement. The issue which arises then is of notice to the other party, which would be through a summary of issues to be addressed, which we do not have. If the defense gives its assurance that it is going to stick in direct examination to the statement and the topics addressed therein, perhaps no summary is required, even though technically it is required under the rules. One last point is in relation to exhibits, which I believe also falls under this agenda item. In relation to the Gucati exhibit list, F460A02, we note that a number of items on that list are clearly irrelevant and or have no decipherable link to any witness the defense intends to call. As such, in the interest of the expeditiousness of the proceedings, we would like to know whether the defense intends to request or to submit a bar table motion, and if so, we can then factor that into our estimates for time and our work planning. I know that Your Honor also mentioned the issue we raised yesterday with CMU in F460A02. I'm happy to address it in private session now or later if you want, but we really don't have anything to add other than what we put in our email, which I believe was also conveyed to the panel as to the need for the reduction of, I think it's just 2 words. So if Your Honor has no more questions about that, or if you don't think I need to go into that any further, those are our submissions. Thank you.
No need to go into that at this time. Mr. Rees, do you wish to respond to any of this, especially the issue about the witness statements and going beyond the terms of the witness statement, and also on the bar table motions?
Firstly, the defence for Mr. Haradinaj will not be leading direct examination of any witnesses that I call. And I do not understand where Mr. Pache has got that impression from. In relation to DW1251, 1250 and 1246, which Mr. Pache refers to, they're not witnesses on our witness list. So I will leave Mr. Cadman to address the position in relation to those witnesses. But in general, we do support the position of Mr. Haradinaj's team in relation to their witnesses, but it is their witness list and it is their case. And I mention in passing because it has already been raised, even though we haven't reached it perhaps on the scheduling order. We object to any suggestion that the calling of witnesses as part of Mr. Haradinaj's case is interposed before the end of the defence case for Mr. Gucati. We object to that as a proposition. We intend, and we maintain it as our right under the rules, to call Mr. Gucati first as in his own defence, and then to complete the Gucati defence case before there are any moves to Mr. Haradinaj's defence case and evidence. We have made full disclosure of detailed witness statements for each of the witnesses we propose to call. We do not need and we do not take any lessons on disclosure, particularly in relation to the issue as to advanced disclosure of witness statements from the prosecution in this matter. We have set out in our witness statements the issues upon which a witness is intended to testify, and if there are to be any additional issues that require further disclosure, we will make such disclosure. But the bundle that we have disclosed, containing detailed witness statements, sets out fully and in detail the scope of the defence case for Mr. Gucati to be called through the witnesses on that list. In relation to the times that we've proposed for direct examination, we intend to take Mr. Gucati through his witness statement in some detail. In relation to the other witnesses, we intend to make use, as we do with Mr. Gucati, but to make fuller use, as it were, of the provision within the rules to adduce the witness statement by calling the witness to effectively confirm the contents of the witness statement and tender the witness for cross-examination. We have provided some time for any additional questions, perhaps to, if necessary, to flesh out any particular area of the witness statement, but that's why we've given short times for direct examination for the other witnesses. We submit that is the proper way of using the rules to make sure that proceedings are efficient and dealt with expeditiously. In relation to any particular sentence that is included in the witness statement that the prosecution takes objection to, our position is this: one doesn't need to go through those witness statements with a fine-tooth comb looking for any particular sentence that the SPO may object to. You are, of course, Your Honours, a professional trial panel, and the statements could be admitted properly with the witness being called and tendered for cross-examination, and then such weight as is appropriate to any part of that weight of that witness statement will be determined, of course, by the trial panel in due course. The only witness to which there is objection in the sense of, to use the shorthand, application to strike off the list, we understand is the objection in relation to the statement of DW1248. I won't use the pseudonym, it's Mr. Bowden who's present in court, of course. And the reason why he wasn't on the original list is because the issue arose during the course of cross-examination of the prosecution witnesses. The trial panel will recall that we were permitted, as a relevant line of questioning, to establish with the witness Zdenka Pampa whether, and indeed with Mr. Halil Berisha, whether articles to which the attention of the trial panel had been drawn by the SPO were still publicly available on websites. The witness was not able to confirm that and declined to do so. The witness statement of Mr. Bowden confirms that those websites are still publicly available. And as I understand, there's no challenge factually to that from the prosecution. So perhaps the matter can be dealt with by way of an agreed fact. But it was a relevant line of questioning. We were permitted to ask it, and we were permitted, it seems to us, to answer it. But we will perhaps address that with a proposed agreed fact to the SPO and see if it can be dealt with in that way. In relation to the exhibit list, that is, of course, a list of proposed exhibits. None of them have been tendered for admission as of yet. We are cognizant of the encouragement from the trial panel at an earlier stage to make use of bar table motions, and we are considering that. The extent to which the list of possible exhibits appears on that bar table motion in full or in part is yet to be determined, but we will make that motion as soon as we are in a position to make that determination. Unless there's anything further in the circumstances, I think that does answer the requests of the Gucati team at this stage.
Mr. Cadman.
I'll try not to repeat anything that Mr. Rees has already said, just to say that I support the position that he's put forward. In particular, just to clarify the point, it is not the intention of the Haradinaj defence to lead any of the witnesses that Mr. Rees has put on his witness list. What was put in the written submissions was that in the event that there are additional questions that need to be put to those witnesses in order for Mr. Haradinaj's defence to be put, then those questions will be put at the conclusion of Mr. Rees's direct examination. But certainly I will not be leading any of those witnesses. That's for Mr. Rees to deal with. In terms of the challenge to the witnesses that has been made, the three witnesses that fall on the Haradinaj list, 1250 and 1251 to deal with that first. We have set out previously why we consider those witnesses to be relevant and necessary to present Mr. Haradinaj's defence of public interest. We maintain the position that we have previously advanced. Obviously, the SBO has set out their objections that have been previously responded to. I don't intend to go into great detail on that now. You now have those statements to consider as to whether they are relevant for the question of determining the public interest. Our position is that it sets out the state of mind of Mr. Haradinaj at the relevant or during the relevant time period. That's also set out also in the summary that we have submitted on his behalf, and a fuller statement will obviously be submitted by 1600 tomorrow as ordered by the trial panel. We maintain that those two witnesses are relevant to the defence of setting out public interest. As far as witness 1246, DW 1246 is concerned, who also appears on the Haradinaj defence, it is relevant to the point as to whether the Kosovo police were directed to conduct any investigation or were actively prevented from carrying out any investigation. For that matter, it's quite clear from that witness's statement what the position was in terms of the SPO providing direction to the Kosovo police. He was a senior member of the Kosovo police at the relevant time. The fact that he was not in the country at the time of the disclosures does not affect the evidence that he can present. He can present as a senior member of the police force what instructions were given to his police force and those officers under his command. Certainly we don't intend to go any further than what's already set out in his statement. In terms of the timings that have been set out, we take the position, as Mr. Rees has already stated, that it will require us to go very briefly through the statements that have already been tendered. There may be additional questions that arise, but we certainly do not extend past those time periods that have already been set out in the 119 filing. The only question is possibly an underestimation of the time allocated for Mr. Haradinaj's evidence. I think it was put on the 119 as 2 to 3 hours. I think it would be more, that would be ambitious to suggest that we would be able to complete that within 2 to 3 hours. I can submit an amended filing. It's likely to take up to a full day, but certainly for all of the other witnesses, we maintain the positions that have already been set. In terms of, I may be jumping the gun slightly, but in terms of any exhibits that the Haradinaj defence is going to be submitting, certainly we will be adopting the exhibit list submitted by the Gucati defence. The additional exhibits are in relation primarily to the 2 expert witnesses and reports that have been referred to within those expert reports. But of course, that exhibit list can be submitted by the close of business today. Unless Your Honour would like me to address anything further.
Thank you very much, Mr. Cadman. The panel will issue an oral order at the end of the hearing on the classification of the Gucati list of exhibits. The decision on the defense witnesses will be issued tomorrow with an oral summary to be provided today. Mr. Potch.
Yes, Your Honour. I'd like to briefly respond to 3 issues raised in the defence submissions. The first is that raised by counsel for Mr. Gucati in terms of the need or otherwise to go to statements tendered for submission pursuant to Rule 154 with a fine-tooth comb. Our position is that Rule 154 should not be used to circumvent the requirements of Rule 138 and should not be used to circumvent what in essence would be inadmissible viva voce testimony by, let's say, and to use a bit of a colloquial term, sneaking that in written form. So as we would object to certain excerpts from statements were they to be elicited viva voce in terms of relevance, we would object, and we do object, to those parts of the statements which are patently irrelevant being admitted to Rule 154. We're not saying the entire statement should not go in if there is irrelevant opinion in it, but certainly those excerpts which are about irrelevant opinion should not go in through Rule 154. In terms of witness 1248, we maintain the irrelevance, and we've heard nothing about why the information therein is relevant to the case. However, and in terms of the alternative offered, we did offer an alternative in our submissions. If the trial panel does deem that evidence relevant, we think it should just be admitted through Rule 153. We do not think it's relevant. If the trial panel does, Rule 153 would be more adequate. If the trial panel or the defense or both feel an agreed fact would be more appropriate, then we could also discuss that, but we did offer an alternative. And the last thing, very briefly, is that it now does seem that the defense will file a bar table motion, so we would ask the panel to set a deadline. I'm not saying to set a deadline now or even to set it for next week, but it's just one of many things which have to happen before the end of the case, and it's one of the things which could require some time in terms of, obviously, defense submissions, our response in the decision, and we would not want that to weigh down or unnecessarily prolong the proceedings. Thank you, Your Honour.
Mr. Cadman, you have the floor.
Sorry, Your Honour, there was just one other matter that I had omitted to raise earlier, and that's in the timing of one of our experts. We have been in contact with CMU as to the timing. Obviously, the expert currently resides in Australia, which is obviously proving a challenge to organise the video link for his testimony. But in terms of the timing, he would not be able to testify before the 17th. I think the 17th would be the earliest day in which he would be available for reasons outside of our control. Obviously, the sooner that we can notify him whether he will be giving evidence or not, the sooner we can get him to firm up his schedule.
Thank you very much, Mr. Cadman. We will address that. Moving on to the next topic, which is cross-examination estimates. The panel notes the submission of the Haradinaj defense that it does not intend to question the Gucati witnesses unless that appears necessary following their examination in chief. The panel also notes the pending SBO challenges, but nevertheless asks for these estimates in the event that these challenges fail. So first, Mr. Rees, do you intend to question the Haradinaj witnesses, or is your submission similar to Mr. Cadman's?
In relation to witness DW1246, I would have, I think, some short cross-examination, perhaps no more than 20 minutes. In relation to the remaining witnesses, then my position would be that any cross-examination would only be in relation to any additional matters that had arisen during direct examination.
Thank you, Mr. Rees. Mr. Prosecutor, what are your cross-examine estimates for the proposed defense witnesses?
Thank you, Your Honor. For the cross-examination of Mr. Gucati, we estimate 10 hours for cross-examination. I'll get into a little bit more detail in a minute. For the cross-examination of DW1241, 1242, 1243, 1244, 1245, and 1247, we estimate 2 hours for each of those witnesses. For 1248, this of course depends on the motion that we filed, where we said if the trial panel does want to hear that evidence, it can go in through Rule 153, which means there would be no cross-examination required. In terms of Mr. Haradinaj's testimony, this very much depends. We received this morning a summary draft statement by Mr. Haradinaj. It looks quite lengthy. We of course have not had time to look at it properly in any way. We understand, although I'm a little confused, that the deadline is set for a full statement by tomorrow, or at least that seems to be what the counsel for Mr. Haradinaj has undertaken to do. We do seek some more clarity about the mode of testimony for Mr. Haradinaj, which is whether it remains as stated in the defense submissions that it is also a Rule 154 admission. So when or if such statement is disclosed, that the intention is to admit that statement pursuant to Rule 154, because that, of course, will have an impact on our estimates for cross-examination. We also, while we're on the matter of the statement or summary of Mr. Haradinaj, it is very important that we do receive any further information before, and ideally as much before as possible, the testimony of his co-accused in terms of preparation. I'll continue on the estimates for other witnesses. For 1254, we estimate a cross-examination of 4 hours. For witnesses 1246, 1250, 1251, and 1252, if they are authorized to testify, which we submit they should not be, our cross-examination would be of about 2 hours for each of them. And for the last witness, the 1253, again, if authorized to testify, which we submit he should not be, the cross-examination would be of around 4 hours. And as I said, these are, of course, estimates. In particular, we know that we've not received any notice of what, if any, exhibits are going to be used with any of the witnesses. So, again, that's something that we would like to receive some clarity about. It could be we have no notice because no exhibits other than the statements will be used. That would be good to know. And in terms, like I said a little earlier, in relation to the cross-examination of the accused, we said 10 hours each, which may change, in particular in relation to Mr. Haradinaj, his mode of testimony, and whatever is going to be contained in any forthcoming statement. But of course, the estimates really will depend on the level of responsiveness to the specific questions put by the SPO. We would like nothing more than to wrap up cross-examination of the accused and any other witness as quickly as possible. Yes, those are our submissions, unless Your Honor has any further questions.
Thank you, Mr. Patch. We can move on to the next topic, which is any further submissions on the elements of offenses and modes of liability. Before I give the floor to Judge Barta, who has some questions, I just want to note that the panel raises these questions because they did not come up in the current form at the trial preparation conference, but they were raised in the submissions under Rule 130. So these are just clarifications the panel seeks of the parties' positions on the law. Judge Barta, the floor is yours.
Thank you, Judge Smith. First, can the parties clarify whether there is any dispute on the specific intent requirement on count 4, that is retaliation? And in this regard, can the SPO please explain how the evidence it deduced under this count ties into this definition? Mr. Prosecutor, you have the floor.
Thank you, Your Honor. In relation to the applicable law, both on the elements of the crimes and modes of liability, in general, we rely on the confirmation decision and our previous submissions. Addressing the specific question put by Your Honor, we rely in particular on paragraphs 52 to 57 of the confirmation decision, and our submission is that the specific intent required for count 4 is that to retaliate, and that is clearly set out in Articles 388, in Article 388.1. I also take the opportunity to clarify what the trial panel asked us to do in our final trial brief now, and here I'm referring to paragraph 65 of the Rule 130 decision, F450, and that is to clarify that the subjects of the retaliation, within the meaning of Article 388, are those persons identified in indictment as quote-unquote witnesses. I'm using quotes because, as everybody knows, witnesses has a specific term, which I remind you, for the SPO, are any persons likely to have information about a crime, the perpetrator, or important circumstances relevant to SC proceedings. Now, in terms of how the evidence supports the specific intent, Your Honor, for us the evidence fully supports the specific intent. I will refer to one category of evidence, which is the statements made by the accused as captured on numerous videos, press conferences, and media appearances, in which they are demonstrating that they want to retaliate against persons who have provided information, who have cooperated with the SPO. And they do this in the various manners which we have set out in our pre-trial brief and also in our Rule 130 submissions. But one way of the retaliation against them is basically through a form of intimidating them, which is to call them out. The act of even making the information available to the media, of making it public. These are all measures which we say demonstrate that they intended to retaliate against people. There is no need for any more direct or specific act than the ones that we have captured in evidence. So our submission is that the evidence fully supports this specific intent required. And those are our submissions at the moment.
Thank you, Mr. Prosecutor. Mr. Rees, any comment from your side?
Well, I won't respond to the submissions made on the evidence that Mr. Patch has just done. We'll reserve that until our closing final trial brief and closing statement. On the specific question that Your Honour raised, we do submit that specific intent requires the SPO to identify the individual who it claims was subject to retaliation. I'm not sure that I need to go any further than that at this stage.
Thank you, Mr. Rees. Mr. Kettman.
Your Honour, I would just say, I would just support what's been said, and it's actually set out in our previous filing on the elements of crime and modes of liability.
Thank you. And the second question is, can the parties clarify what their position is on whether proof is required under count 6 that the protective measures were still valid and in force at the time of the alleged commission of the offenses, that is in September 2020. And I'm especially asking in relation to protective measures allegedly granted by courts other than this court. Mr. Prosecutor.
Thank you, Your Honour. On this subject and on these counts, the SPO relies on paragraphs 34 to 50 of the confirmation decision, in particular on the definition of protected information for count 5, that's at paragraph 37, and of protected persons for count 6, and that's at paragraph 44, and these show that these notions are broad ones. In particular, Article 392(2) and 3 do not specifically require any specific or formal protective measures of protection or a protection order as such. So court-ordered protective measures from this or other courts are one way for persons to qualify as protected persons. But even if such measures did not exist, the witnesses in this case would still be protected within the meaning of the law because of the definition provided, which is, we submit the correct one. All that is required under the relevant subarticles is that the unauthorized revelation of information on the identity or personal data of a person under protection in criminal proceedings, bless you, or in a special program of protection. So the wording itself supports what we're saying and what the pretrial judge said, that no specific court-ordered protective measure is required. Nevertheless, I will make a few points in relation to court-order protective measures, bearing in mind the question put by the panel. The trial panel has admitted relevant evidence showing that certain KSC-ordered protective measures have not been varied. Those related to cases 4 and 5 before this very court, and those are cases, one of which is at pretrial and one is at trial. Furthermore, this panel has also admitted evidence that SPO requests for protective measures were pending before the pretrial judge in other proceedings. The evidence I'm here referring to are P151, P152, and P154. And this latter request is a further indicator that formal measures of protection were being adopted. In relation to relevant protective measures ordered by Kosovo courts, the SPO was not aware of any relevant rescission of such orders at the time the charges were brought. If we were, we would not have brought the charges or mentioned those specific factors. Neither does it have any information indicating that at present. And we also know that proof that these measures have not been varied for certain specific witnesses would inevitably identify witnesses who testified under protection in previous proceedings and who the SPO intends to rely on in other cases. And those are submissions on this matter at the moment, Your Honour. Thank you.
Thank you, Mr. Prosecutor. Mr. Rees.
Again, I won't address the evidence that the trial panel has heard. We will reserve our position to do that in our final trial brief and our closing submissions. Moreover, I will ignore the attempt by Mr. Pache then to give further evidence on the point. Of course, the prosecution's case has closed, and no other evidence from the SPO is to be admitted. In relation to the specific point that you asked, whether proof is required that the confidential classification and/or protective measures are still valid and in force at the time of the alleged commission of the offences, we have submitted that previously and we maintain that position. And that will be our position in our final trial brief and closing statement.
I thought so. Thank you, Mr. Rees. Mr. Cadman.
Regarding the evidence, the same position is taken, and just to refer back to what I'd said previously, it's actually F00342, which is the Haradinaj filing under paragraphs 6 onwards. We deal specifically with that issue.
Thank you, Mr. Cadman. Judge Smith.
Mr. Cadman, one other question doesn't have anything to do with this, but this is just for planning purposes. At this time, do you intend to have Mr. Haradinaj give his testimony, in his direct testimony in chief, orally or by submission of 154, the document?
He will be giving oral evidence.
Okay. Thank you. The next topic concerns the outstanding video link application. The panel notes that the witness in relation to whom the application is made is also subject to an SPO challenge, and that's defense witness 1253. Nevertheless, the panel inquires with the prosecution whether it wants to make any further submissions in relation to the video link application of this witness.
Thank you, Your Honour. I briefly read the registry's submissions on this matter, which were notified this morning, and from my brief reading thereof, it seems that the requirements which we had initially requested for video conference evidence of this witness could be met. And just to reiterate those, it would be that we would not oppose, obviously we oppose the testimony, but if the testimony is going to happen, we would not oppose video link for that witness on the terms that we do intend, more likely than not, to show confidential documents, so it has to be a secure link. We do want the witness to be able to look at the confidential documents and that the security of these documents is maintained. And we do envision the possibility of going into private session, so that is also an important requirement. Again, from what I read this morning very quickly before I came to court, it seems that the registry is well on top of this and that all those issues can be met. So those are our submissions at the moment. Thank you.
I would just concur that the registry is taking care of matters as best they can in the circumstances. I agree that there will be certain aspects of the witness's evidence that would need to go into private session. There may even be, we obviously haven't made an application on that basis yet, but some of the video footage that would need to be in private session as well. Once Your Honours make a decision on whether the witness can be called, then we can make a decision as to the course of his testimony.
Thank you, Mr. Cadman. The panel will now address some of the matters raised by the parties yesterday via email. Excuse me. The Gucati defense raises a question regarding the outstanding assessment of the necessity of Mr. Gucati's continued detention to be carried out upon receipt of the responses from the Kosovo Police and the Registry in accordance with paragraph 34 of filing F-390. The panel welcomes this question and takes this opportunity to provide information on the further steps to be taken. The panel notes that the Kosovo Police filed its report on 25 November 2021 and that the Registry submitted its report on 26 November 2021. The panel was informed this morning that the English translation of the Kosovo Police report is ready and will be distributed shortly, if it hasn't been already. The panel will review the police report and then order the parties to comment on both reports if they so wish. In view of the approaching 2-month deadline, the panel will also order the SPO to make its submissions regarding continued detention. The panel expects to issue this order to the parties either tomorrow or on Monday. Any questions or comments at this time from either of any of the parties? Nothing from the prosecution. Mr. Rees, anything? Mr. Cadman?
Just it wasn't clear when the order for the SBO to respond is to be.
Either
you
tomorrow
said you want to make
or
a decision.
Monday. Either tomorrow or Monday.
So it's for the SBO to file their submissions.
No, we will order them to follow the submissions. We haven't set the date yet. To be clear, the order setting out the time frame will be issued tomorrow or Monday. The panel notes that the second question raised by the Gucati defense, which reads as follows: who do the SPO intend to tender as a witness for cross-examination to deal with the recently received and outstanding disclosure as to how the batches arrived at the offices of the KLA WVA? If the panel understands your question, you are referring to the outstanding matter regarding item 202. The panel notes that no decision has yet been rendered on this item. Moreover, even when a decision is rendered, the panel's oral order was that the defense indicate whether it requests further cross-examination. The defense should at that juncture indicate which of the 3 SBO staff who testified in this case it wants to cross-examine further. Mr. Reese, do you have any further submissions to make at this point?
I do, and the request, just for clarification purposes, not only in relation to the outstanding item on the Rule 1023 notice that's yet to be ruled on, but also in relation to the 2 matters of disclosure that we did receive post-closure of the prosecution's case. So we're conscious that the oral order previously made about any request for further cross-examination of prosecution witnesses that have thus been called, the trigger point has not yet been reached because there is still outstanding Rule 1023 matter. But I raise a point, I'm conscious I've raised it before, but I repeat it in light of the disclosure that we have received. None of the 3 witnesses the SPO have called thus far can assist with the matters that are being disclosed. They made that clear when they gave their evidence directly in response to questions as to what extent they could assist with matters about the investigation, as to how the documents were, the process by which the documents arrived at the KLAWVA. Matters have been disclosed to us, and it seems to us we would submit only fair that the SPO, even if they weren't to call a witness, to tender a witness for cross-examination, gave us a name of a witness within their ranks that we could witness summons to attend for us to ask questions about this disclosure. Because the choice about further cross-examination of Ms. Pemper or Mr. Dukic or Mr. Moberg is no choice at all, really, because they've made it clear they cannot assist with these matters. They don't have the knowledge, they're not in a position to. So we repeat our submission that the SPO should put forward an officer from their ranks who is able to assist on questions as to the SPO's knowledge or the process by which the documents arrived at the KLAWVA. That doesn't require them, for example, to give a witness statement or a declaration to have direct examination, but at least to give us a name that, if necessary, either they can be tendered and we can cross-examine them on the disclosure that's been made, or they can give us a name and we can apply for a witness summons for that person, and we'll have to call them as a witness ourselves. That's the issue that I raise, Your Honour.
Understood. Thank you. Thank you for the clarification. Mr. Cadman, anything to add to that? Thank you. Mr. Potts, you wish to respond?
Thank you, Your Honour. First of all, the items being discussed were disclosed pursuant to Rule 1023. We did not tender them for admission, neither do we ever intend to do so. We maintain and repeat our submissions that these related matters irrelevant to the case. Of course, we respect the decision of the judges and we disclose them, but to that end, the SPO has closed its case and does not intend to call any witnesses in relation to these matters in particular or otherwise. The counsel for Mr. Gucati makes an argument about fairness, but there is no legal or jurisprudential basis for an obligation for the prosecutor to call a witness for the purposes of the defense cross-examining that witness. And more specifically, there's certainly nothing to support a request that the prosecution identify a potential witness for the defense. That's not something we should or need to do or that we intend to do. So again, Your Honour, very briefly, we've closed our case and we do not intend to call any witnesses in relation to these issues at the moment in relation to others either, but of course the situation may change because the defense case has yet to start. Thank you.
The panel wants to hear the parties on some of the upcoming deadlines. In line with Rule 134, after hearing rebuttal or rejoinder evidence, the panel must announce the closing of the evidentiary proceedings and invite the parties to file their final trial briefs within 30 days. According to the same rule, closing arguments are to be heard within 21 days after the filing of the final trial briefs. Now, keeping in mind that this is a case falling under Rule 72 and expedited proceedings are allowed, the panel is minded to shorten these deadlines, but it first wants to hear from the parties on how short the deadlines could be. So we ask you to think about that just for a moment, and we'll start with the prosecution. If you need a minute, take the minute. That's fine. Same with the defense counsel.
Apologies, Your Honor. Yes, I need a minute. Thank
All
you.
right, that's no problem. Ready, Mr. Potch?
Yes, thank you very much, Your Honor. The SPO would be in a position to file its final trial brief within 3 weeks of an order to close the case. To be clear, that is either when the defense is not calling any more witnesses, if there are no further witnesses and no further pending decisions, for example, a bar table motion, or after any bar table motions or rebuttal witnesses. So we need a 3-week time frame for the pretrial brief. After that, we would like, at the minimum, 1 week for us to prepare our closing submissions. Thank you.
Thank you. Mr. Rees?
As an introduction, I say that we do not accept that this is a case that does fall within Rule 72 in expedited proceedings, but we nevertheless accept that there is a wider power to shorten time limits that are within the rules for good cause, and we are as anxious as anyone that these matters proceed expeditiously and are resolved as soon as possible. We would therefore agree with the prosecution that the limit for final trial briefs could be reduced to 21 days. We would agree with that. In terms of thereafter scheduling a hearing, again, we would ask for a minimum of a week thereafter to prepare the closing statement.
Thank you, Mr. Rees. Mr. Cadman?
Well, let me expedite my submissions on this and say that I think 21 days for the final trial brief and a further 7 days thereafter for closing arguments is entirely reasonable and completely doable.
We have reached the end of our agenda. The panel is going to adjourn briefly. I think we'll be back here at 11:30. Give us time to take care of some small orders. Before that, does any party have anything else they want to raise at this time? Mr. Potch?
Thank you, Your Honor. The first will be just to repeat that if the defense intends to use any exhibits with witnesses, we do expect notice thereof as soon as possible. And that applies to both defense teams because the requirements in the order of the conduct of proceedings have a requirement that a tentative list of proposed evidence to be used with witnesses is provided well in advance. We know that the presentation queue is to go in, I believe it's 24 hours before, so that's not what I'm talking about right now. The other matter I would like to raise is that we note that in the statement by DW1242 to the Gucati defense, the witness makes reference to having been part of an interview with the Haradinaj defense. So we would like a disclosure if there is any statement arising from that interview. And that is because the witness is being called to testify, so that is a relevant statement for us. It's not clear from the paragraph if a statement was taken, perhaps it was a meeting. We understand that if no statement was taken, there is no disclosure obligation, so that is what we seek to clarify. In our inter partes request a couple of days ago, we did request disclosure of any statements, and other than the exhibit list issue which I mentioned for the witnesses and this one particular statement, that's what we have for the moment. Thank you.
Could you clarify on this?
What's quite clear from the witness's statement is that an initial discussion took place as to whether she had any information that was relevant to the case. A subsequent statement was taken by our investigator. Well, I can obviously file a submission to that effect, but in the witness's statement, it says that an initial discussion had taken place with me, and then the statement was then taken at a later date. An initial statement wasn't taken on that first occasion. It was really to identify whether she had any information that was relevant to these proceedings.
So there was no statement.
No,
All right,
no.
thank you very much. Does that satisfy you, Mr. Potch?
And if there is no statement or not, I do not know that, but just to clarify what the Gucati defense statement says in paragraph 1, is I have been interviewed previously in the capacity of a witness in the case of Gucati&Haradinaj, the president of the KLA War Veterans Association, from Lord Toby Cadman and the name of a translator. So it appears that there was an interview in the capacity of a witness. Again, I repeat, we understand that if it could be no statement was taken, and if that's the case, there is no disclosure obligation arising from the defense. If a statement was taken, which could be or could not be, then not. If
I
Mr.
believe you
Cadman
just
says-
said there was no statement taken.
Yes, if there was no statement taken, then fine. I just wanted to clarify that it does seem that it was an interview in the capacity of a witness per the statement itself.
Mr. Cadman?
But I can say it again, Your Honour. There was no statement taken initially. It was merely a scoping exercise. A subsequent statement was taken by our investigative team, which has been disclosed.
Thank you, that's clear to me. Thank you.
Sorry to rise again, Your Honour, but what has been disclosed is a statement, if I'm not mistaken, by the Gucati defense. I have not seen, I may be missing it, it's very possible. In the last few days there's been a lot of disclosure, but I have not seen a statement by the Haradinaj defense of this witness. So I do seek some clarity on this matter, because it does in fact appear that there is a statement by the Haradinaj defense for this witness.
It is her statement that was taken, which has been tendered by the Gucati defence team.
Thank you. So we will have you back here at 11:30.
Can I raise one matter?
Oh, yes, Mr. Rees.
Relatively briefly. Obviously, we did touch upon the scheduling of a further hearing for closing statements. We did so with a view to looking at the timetable set out in Rule 134 for the preparation of final trial briefs, and then thereafter the scheduling of the hearing. But of course, the scheduling of the hearing itself is a matter which doesn't necessarily follow as easily as saying you only need at least a week after the service of the final trial brief. There are commitments involved that mean that the scheduling of the hearing itself is an exercise that we would obviously wish to participate in the discussion of. I understand that Your Honours will be looking at setting out a proposed provisional schedule for the presentation of evidence up to the 17th of December. If the trial panel is considering setting dates beyond the 17th of December, we would like to address the trial panel because, and we are conscious that some preliminary indications have already been requested as to availability, but we would like to expand upon that further if the trial panel is going to consider for setting dates down beyond the 17th of December.
Why don't you go ahead and state what your concerns are for that? Let's assume the first part of January, for example.
Well, the trial panel knows already that my professional commitments are such that I am not available until the 28th of February. because of a commitment that I begin on the 4th of January. We have from the very outset set down a timetable, at a point at which the SPO was suggesting the matter could have been heard in 3 days in March, I think. From the very earliest stage, we set out what we thought was a realistic timetable that led to the trial being able to start and be completed in the autumn term of this year. And I hope the trial panel recognises that there has been no delay caused by us. We've given time estimates that we have bettered in the event. The only delays that have been occurred and continue to occur are to do with disclosure issues that the SPO have, we say, and the trial panel knows this, never properly engaged with, despite the fact that we raised those at the earliest stage so that with proper engagement they could have been resolved well in advance of the beginning of this trial in September.
Rather than going into whose fault all this is, could you just tell me what your concerns are for timing?
So firstly, I'm concerned that any date for closing statements is set down a day which I am available to attend and present the closing statement for. I would also wish if we continue with evidence past the 17th of December, that I'm in a position to be able to attend that hearing. Now, I know that involves some delay, but my availability is such as that I would ask the trial panel to consider that period with the week commencing February the 28th for us to return to continue with any hearings before this trial panel.
How firm is your commitment in January and February?
Very firm.
No way of changing that?
No.
You have co-counsel?
I do have co-counsel, and obviously we are in the trial panel's hands. I've made the request. Certainly for closing statement, my submission would be that's a matter that should be done by counsel. So I certainly ask the trial panel to take into account my availability when setting a date for any closing statement. We are, of course, as we always are in the trial panel's hands, as to all dates. But I've made my request.
So to be clear, after the 17th of December, your next available date is the 28th of March, your personal next
28th
date.
of February.
I'm sorry, 28th of February.
Yes.
Okay. Anybody else want to weigh in on these issues? I'm assuming right now that we're not going to be finished with everything by the 17th, even though we had hoped ourselves that we would be.
Well,
I mean, I've listened to you estimate the times to examine your witnesses, and it's going to take a certain amount of time. That's all.
Well, absolutely. And despite the fact that we gave full notice of the overall shape of our defence cases at an early stage, we were dealing with defence witness lists as part of the prosecution trial preparation conference. The trial panel will, of course, recall. But it's nevertheless complete news to us that the SPO intends to take 10 hours with Mr. Gucati. That is the first time we've had any sort of indication as to the length of time the SPO intends to take with the witnesses of which they have had notice for weeks and weeks now. We have throughout urged that this trial, the evidential proceedings at least, be concluded by the 17th of December. We did that in the prosecution preparation conference, the trial preparation conference. We still urge it now.
Well, if everyone would be cooperative, maybe we could still do that. And I'm not willing to just forego that at this time. I think that's still what our aim was. And I would ask everyone's cooperation in trying to finish the evidentiary stage by the 17th. Mr. Potch?
Thank you, Your Honor. I'll start by the more recent submissions by counsel for Mr. Guzzati. First of all, the complete news of our time estimates is entirely right. It's complete news because the first time we were required to provide those estimates is a couple of minutes ago. Second of all, being on notice of weeks of testimony of evidence in no way has an impact on the length of the cross-examination. In particular, although very minimalistic summaries of anticipated evidence were provided, no statements were provided until 1 or 2 days ago at most. And it is only on the basis of those statements which enabled us to prepare an estimate for cross-examination. I fail to see how anybody in this courtroom could be surprised by our estimate to spend 10 hours on the cross-examination of the accused in this case. That certainly cannot be surprising, especially when we have, for Mr. Guzzati, a detailed statement. We have a lot of relevant material, and at the end of the day, it is the accused's choice to take the stand. So that should not surprise anybody, and we certainly, while we intend to be as efficient as possible, do not intend to truncate our cross-examination or our case to make things go quicker. The estimates for the other witnesses we think are valid, we think they're reasonable. Again, we could try to do our best to keep those cross-examinations shorter. We also have every intention of finishing this phase of the proceedings and the proceedings overall as soon as possible. I will turn to the submissions in terms of availability. While it is unfortunate that counsel for Mr. Guzzati may not be available until the end of February, that is absolutely not a reason to in any way delay the proceedings. It is unfair to the SPO. It is also, frankly, unfair to the accused, who should not be made to wait an extra 2 months in detention pending proceedings simply because counsel has other engagements. We do note, as the presiding judge has noted, that there are co-counsel in the case. In terms of being present, at least for closing arguments, that's a little premature. It may be that that aligns well. It could be the closing arguments will be after the 28th of February. But our submission is that the unavailability of counsel because of another engagement is absolutely not a reason to delay anything in the schedule as set forth. It does seem possible that most of the Guzzati witnesses could be completed in the next 2 weeks. Possible. I cannot guarantee that. I don't think anybody here is in a position to guarantee that. And that, of course, would make things perhaps a little bit better, which would mean at least counsel would be able to finish the direct examinations of his own witnesses. But even if that were not to be the case and counsel would not be available for direct examination of his team's own witnesses, that is not a reason to delay that examination, Your Honor. Those are our submissions, and thank you.
Thank you.
One thing, Your Honour. I make the submission conscious that there is the forthcoming review on detention, and conscious that, although we look forward to receiving the English translation of the Kosovo Police report, from what I understand of the report, there are very sensible concrete proposals which give a real alternative to detention within the DMU here. And we will be pressing for Mr. Guzzati's release in light of that report under the conditions envisaged by that report in due course.
I will only say that I expect everyone to do their best to limit their questioning to relevant material, because I have seen some instances already where it has not been always relevant material. I know I haven't been around as much maybe as you people have, but 10 hours cross-examination is a long cross-examination. And the best cross-examinations I've ever seen are a lot faster than that, with very targeted questions. So I want you to think about doing this, and not only the cross-examination, but I think, Mr. Cadman, you indicated all day for Mr. Haradinaj, which might also be a bit excessive. So let's try to all think about getting this evidence in the appropriate time period. I'm not picking on you, Mr. Cadman. I'm just telling you that that's a long time also. So go ahead. If you have a comment, make it.
I'd rather overestimate than underestimate.
Well, I know, but now we're to the point that we're trying to plan, so I want you to rethink your estimates.
Understood, Your Honour. The only point that I would make, I think that gives further force to the argument that the entirety of the Gucati defence should go first in light of the difficulties that Mr. Rees may have. Of course, we will do everything we can to have everything finished by the 17th.
I understand what your position is, and frankly, with Mr. Haradinaj having some difficulty being here, I don't disagree with you.
I'm grateful.
Okay? I'm sorry, we are adjourned.
All rise.
The panel will now issue a number of oral orders. The first oral order, this is in fact a summary of the panel's decision on the motions filed by the SBO to strike witnesses from the defense lists of witnesses and seeking other related relief. A fully reasoned written decision will follow tomorrow. Regarding the prosecution's first application, that is F312, the panel will only address the witnesses who are still proposed to be called by the defense. In relation to the Gucati defense witnesses 1241 and 1242, while the panel considers that some aspects of their statements are of questionable relevance, it is not satisfied that their testimony as such should not be allowed, as there are aspects of their proposed evidence that are clearly relevant to this case. This panel therefore allows these witnesses to be called, but directs the Gucati defense to ensure that evidence elicited from those witnesses is strictly relevant to these proceedings. In relation to the Haradinaj defense witness 1246, the panel is satisfied that the proposed evidence of this witness appears to be relevant to the claim of entrapment advanced by the defense. The panel therefore allows this witness to be called on that basis without prejudice to the question of the availability of an entrapment defense under the applicable legal regime. In relation to the Haradinaj defense witnesses 1250 and 1251, the panel finds that the defense has failed to demonstrate the relevance of their proposed evidence. The panel therefore declines to hear these witnesses and will not permit the Haradinaj defense to call them. Regarding the prosecution's challenge against Haradinaj's defense witness 1252, an expert witness, that is F388, the panel finds that parts of the witness's proposed evidence are objectionable on the ground, inter alia, that they overstep the boundaries of permissible expert evidence and impermissibly stray into the territory and responsibilities of the panel. The panel will therefore disregard the following paragraphs of the witness's expert report as being impermissible. Paragraphs 23 through 25, paragraph 32 and 34, second sentence, paragraph 36, second sentence, and paragraph 40. For this reason, the panel allows defense witness 1252 to be called, but will only permit testimony in respect of certain general legal propositions contained in those reports of those parts of her report that do not constitute impermissible evidence. Regarding the prosecution's challenge against Haradinaj's defense witness 1253, a second expert witness, that is F438, the panel has no doubt that the proposed expert is an experienced and highly qualified criminal investigator. However, the panel finds that the proposed evidence of this witness relates to issues which the panel can determine for itself without the assistance of expert evidence. They are legal, factual, and evidential issues that the parties have raised as part of their case. The proposed evidence would therefore usurp in several respects the panel's responsibilities. The panel therefore declines to hear defense witness 1253 and will not permit the Haradinaj defense to call him. Regarding the prosecution's challenge filed yesterday, that is F466, in relation to the Gucati defense witness 1248, the panel finds that there is no dispute between the parties that the articles referred to in this statement of this witness were still available online at the time relevant to his account. Therefore, the panel can take note of the fact as agreed between the parties without the need to call defense witness 1248. If the defense wishes, however, to tender that statement in evidence, it can offer it for admission pursuant to Rule 153, as suggested by the SPO. In relation to Gucati defense witness 1243, 1244, 1245, and 1247, and the Haradinaj defense witness 1254, the panel agrees that some parts of their statements constitute opinion evidence, and some of it might not be relevant to these proceedings. However, the panel considers that this evidence has yet to be elicited or offered into evidence. If and when this were to occur, the prosecution can object to the evidence being elicited or to the statement or parts thereof being admitted in evidence. The panel therefore finds that it is premature to rule on their admissibility at this stage. This concludes this oral order. At this point, I want to stop with the oral orders for a moment and ask the prosecution and Mr. Reese a question. The panel intends to grant leave to the defense to appeal part of the panel's decision should they wish to do so. This would be set out in the panel's decision to be issued tomorrow, if so decided. The proprio motu certification would concern the panel's findings in relation to defense witnesses 1250, 1251, and 1253. Would the SBO object to such a decision on certification without application, in the interest of expediency?
Your Honor, we would like to see an application because we want to see how the issue is framed.
Knowing that that will extend these proceedings quite some time?
I don't see why it would extend them significantly. A request for leave to appeal from a decision could be provided in a few hours, but we should be granted the benefit of seeing how the issue is framed. That is very relevant.
So we will determine this matter in our decision tomorrow. Thank you. Mr. Reese, having heard the gist of our decision to be issued tomorrow, are you in a position to make your opening statement tomorrow morning? You do not have to. You can elect to wait until the decision, but we are offering this option to you based on your submission earlier today.
Yes, I would be.
All right. Thank you. Now we will continue with the oral orders. Second oral order, after having heard the parties and pursuant to Rule 119, subparagraph 4, the panel sets the date of the opening of the defense case to be 3 December 2021. The panel notes that the Gucati defense will make its opening statement on 3 December 2021. The presentation of the Gucati defense evidence is expected to begin on 6 December 2021. The panel authorizes the Haradinaj defense to make its opening statement after the end of the Gucati case. The presentation of the Haradinaj defense evidence is expected to begin immediately after its opening statement. The evidence in these two cases will be heard between 6 and 10 and on 16 and 17 of December of this year, and, if need be, between 11 and 17 January 2022. The panel reminds the defense of its obligations under paragraph 59 and 62 to 65 of the Order on the Conduct of Proceedings. The SPO is reminded of its obligations under paragraph 66 and 67 of the same order. This concludes the oral order. The third oral order. In connection to the previous oral order and the decision to be issued tomorrow, the panel finds it necessary to issue the following warnings to the defense. The panel reminds defense counsel that as the calling party, it is their obligation to lead the questioning in a responsible and relevant manner, bearing in mind prior decisions of the panel. In this regard, the panel notes with concern that a number of documents appearing on the defense exhibit list do not appear to be relevant to these proceedings. The panel reiterates that the justness of the war or the commission of crimes by any party during that conflict are not issues relevant to this case, and the panel will not allow the eliciting or tendering of such evidence. Testimony about the character of the war or illegal acts allegedly attributed to any party to the conflict or individuals are not relevant to the charges in this case. Questions along those lines or answers given by the accused or witnesses on those subjects will be interrupted and stopped as irrelevant. The panel also notes that several of the items appearing on the defense list of proposed exhibits are lengthy documents. In line with paragraph 19 of the order on the conduct of the proceedings, the defense should be prepared to identify specifically which parts or sections of those documents are being relied upon in respect of their case. The panel will not allow the records of these proceedings to be unnecessarily loaded with material that is not relied upon by the parties. Fourth oral order. After having heard the parties and pursuant to Rule 119, subparagraph 4, the panel sets as target date for the closing of the defense case the 17th of January 2022. This date is set out in an abundance of caution in order to allow ample time for the defense case and accommodate any interlocutory appeals. The panel stresses that this target date is a mere indication of its estimates. It can be brought forward or extended as necessary. This concludes this oral order. Fifth oral order. The panel notes that on 8 September 2021 at the prosecution's preparation conference, the panel set the 17th of December 2021 as a target date for the closing of the case. The panel now wishes to revisit that indication and to set a new target date, taking in consideration the current stage of the proceedings and the steps that still need to be followed. The panel stresses that these target dates are mere indication of the panel's estimates, but they are subject to the development of the proceedings and to the principle of a fair and expeditious trial. At this stage, the panel still needs to hear the defense case, decide whether it wishes to invite or call further evidence, plan for any rebuttal or rejoinder evidence, set a deadline and receive the final trial briefs, and hold a hearing for closing statements. The panel accordingly sets as a target date for the closing of the case as the 1st of March 2022. Again, the panel stresses that this target date is a mere indication of its estimates. It can be brought forward or extended as necessary. The panel will invite submissions from the parties on interim deadlines in due course. This concludes this oral order. Sixth oral order. The panel, having heard the parties, finds that the Gucati list of proposed exhibits, that is F460, Annex 2, may retain its current public classification. The panel finds that while the name of the entity in question appears under item 25, the generic manner in which the subject is identified raises no concerns as to the disclosure of confidential information. This is without prejudice to the panel's position regarding the classification of the extract under item 25 and the manner in which the evidence therein may be elicited during public sessions. This concludes this oral order. Seventh oral order. The panel orders both defense to file an updated exhibit list conforming to paragraph 60.E of the order on the conduct of proceedings by Monday, 6 December 2021 at 1600 hours. This is without prejudice to the Haradinaj defense filing its exhibit list today. This concludes the oral order. The eighth oral order. The panel orders the defense to file a bar table motion, if any, by December 10th, 2021, and for the SPO to respond, if it so wishes, by 15 December 2021. This concludes the last oral order. Anything further from the panel? As indicated by Mr. Reese, we will begin with opening statements tomorrow, so I will expect to see all of you here at 9:30 tomorrow. And thank you for your attention today. Thank you for the translators and interpreters, court reporter, and all other assembled parties that have helped make this day. We'll see you tomorrow.
All rise.